attorneys, technical things.
We write the laws clearly not well, but we also get to enforce them too.
This is the old one. It's going to be great for you. This is your new partner.
From
You guys are going to be a team.
the original
Every board
fence
needs to include that.
Generally, that's me. So
She
I like
fits
to know
great
that I
with
have
you
a
guys.
partner in crime.
You do?
Fantastic. And every meeting will go smooth and swimmingly.
No, she did it once in
So,
2014,
Mr. Elliott returns.
and then,
That's right.
well, actually, it is the third time.
Oh, you will like it.
One time, and then we, yeah, we
Oh, yeah, I can't wait for you to hear
Right.
from me.
and
That'd
then
be
we
awesome.
said no.
I'm waiting for that day. I might
And the
call
attorney
him
will
up and
explain the
schedule
procedures
appointments
for the
both of you guys
rehearing
to
and
meet.
everything.
Okay.
Have you come over and visit?
Okay, all right.
Have you not met her, Elliot?
I have not.
Okay.
To my knowledge, I have not. I shouldn't say that I haven't, because there's a chance I might have, but I feel like based on this short conversation, I would remember that.
But at least not in courtroom setting.
I think she would remember.
No, not in the courtroom setting.
He's a person you would remember.
You'd be surprised.
No, you would
Lots of people
remember.
are not memorable to me. Oop, I think we're at 7 o'clock. You want to call the order? I think it's 7.
Is it?
Well,
that
that
clock
clock says we've got 15
Yeah, it is.
minutes, but
That
that's
clock
wrong.
does not count.
Wow. Thank you for that. It is
Someone
7.
else our TV guy?
Okay,
I
call to
figured
order.
I'd come to order then.
Meeting of the Board of Adjustment, March 23rd, 2016, regular meeting.
Mr. Elliott? Mr. Rabowski?
Here.
Mr. Alahousas? Mr. Burris?
Here.
Mr. Eisner?
Here.
Ms. Sanner?
Here.
Okay, we go to the quasi-judicial announcement and swearing in of speakers.
This is a quasi-judicial proceeding where the Board of Adjustment acts in a quasi-judicial rather than a legislative capacity. At a quasi-judicial hearing, it is not the Board's function to make law, but rather to apply law that has already been established. In a quasi-judicial hearing, the Board is required by law to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The Board may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has met the criteria established in the Code of Ordinance, then the Board is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinance, then the Board is required by law to find against the applicant. Would any person testifying here today please stand and raise your right hand to be sworn in? If anyone is planning on speaking, are you planning on presenting today? Okay. If you would stand and raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Being so sworn, I'd like to address the first application. It's a little bit different than what we're used to. Application number 15-116, variance to increase the maximum height of a fence. This is a rehearing request. A little bit of background on the rehearing request. The Board, this is a two-step process. It's my understanding this is the first time or in a very long time that a rehearing request has come before this Board. The first step is that the Board is going to hear testimony concerning evidence that has not previously been considered by it. If the Board determines that the testimony that you've heard is compelling enough to show that there is in fact evidence that has not previously been considered, then you are to vote to grant a rehearing. If the Board, after hearing testimony, comes to the conclusion that there is no compelling evidence that has not been, or that if there is no evidence that is new and has not been considered, then you are to deny the rehearing. After that, if you do grant the rehearing, then the applicant is to go ahead and apply for a new variance, and we will go ahead and notice it as like a new application. It will be noticed and presented, and then you will determine whether or not to grant the application or deny the application at another meeting. Just today, on this rehearing request, all you are to do is to consider the testimony by the applicant and consider whether or not the evidence that is presented is new and has not yet been considered. If so, you grant the hearing request. Are there any questions?
Yeah, so there will only be testimony from the applicant, not from the city?
That is correct.
Thank you.
Are we supposed to ask any questions of the applicant?
You can ask questions of the applicant, but again, it is only to the point that the evidence that there is additional evidence that has not yet been considered. So while you can ask questions, the question should only be to, is this something that's been considered before? Is this new evidence? Have we heard this before? Those are the only questions that are pertinent to the rehearing request.
Any others?
I have a question. If a question wasn't answered on the last hearing, can we re-question?
Only if it has to do with whether or not the evidence that is presented is new or if it is something that was presented previously.
Okay.
So it's not towards the application itself, it's just whether the evidence is new and has yet to be considered or has already been considered.
Okay.
That's the only determination you need to make today. Okay. With that being said, we can have the applicant present, yes, the new
You just want to come to the
evidence.
podium and just state your name for the record, your address.
I am a homeowner of 1401 Meyer Lane in Tarpon Springs. My name is Anastasia Knecht. And,
Pardon, could you speak into the
You
microphone
have to
directly,
speak
please?
into the microphone directly so we can hear you.
Thank you.
okay, so I'm very sorry. I am an owner of the house 1401 on Meyer Lane in Tarpon Springs. And I do believe that I have additional evidence for you. I wasn't really very prepared for the last time, but this time, based on the suggestions made during the last meeting, first of all, I want you to consider the topographical change of elevation of the front yard area due to the easement along Meyer Lane. The 1401 Meyer Lane house was constructed approximately 3 to 4 feet above the Meyer Lane road surface due to the easement and rainwater drainage system. The slope of the front yard toward the easement on Meyer Lane does not allow placement of a 4 feet front yard fence on the same topographical height as the main house. Also, the uneven topography of the front yard slope toward the Meyer Lane easement does not allow construction of a retaining wall in order to place a 4 feet fence on the same topographical height as the main house. The elevation of the maximum height of the proposed front yard fence is the only feasible solution due to the specific of the topography of the front yard area. And I apologize, but I did want you to look at the pictures that I made just recently, so if you don't mind. And if you can see, I constructed and I do have the permit applied for the 4 feet. So, and you can see how low it is because of the very slope is very significant. The second evidence I want you to consider was basically a question presented to me during our last meeting. The member asked me how the neighbors would consider this structure and how it will impact the entire view of our neighborhood. We have only, if I'm correct, like 9 houses on our street. And well, I wasn't sure really. I didn't personally talk to all people. So they didn't come to the last meeting, so we assumed they don't mind. However, since this question arose during like last meeting, so I personally went to every house and asked each owner, so what do they think about increasing this fence like 2 feet high? So every single house on our street signed the petition. This is a petition from Restoration Subdivision to the Planning and Zoning Department of the City of Tarpon Springs, and it states that the abandoned construction located at 1400 Meyer Lane, Tarpon Springs, represents a danger to the neighborhood. The unsafe environment forces the owner of the house located at 1401 Tarpon Springs to increase the height of the front yard fence from 4 feet to 6 feet. Neighborhood residents agree. The location and the overall height of the proposed front yard fence will not jeopardize the aesthetics and well-being of the neighborhood and, in fact, will beautify the entire area. And every owner of every house in our neighborhood signed this petition, and I have the original signatures here. Okay, so this is the second one. Also, I have people who are living like next to my house on the street and across the street in the very close proximity to the abandoned construction are willing to come to the next meeting and present their evidence of unsafety. They have cameras and they have photos and they know what is going on if you want to have this presentation. And the last thing, I just want to basically point out that I did have the permission 2 years ago on the same adjustment board to increase the height of the front yard fence from 4 feet to 6 feet located on the left side of the front yard, which basically the same area, the same front yard. And this petition 2 years ago, I have a copy of it. It was approved. So wasn't any discussion, no problem, was just approved on the left side. However, I just want to move the front yard more to the right to protect the entrance to the front door. So this is for you just to basically consider this approval, because I already have it. It's right here.
Okay, does that complete your presentation this time?
Yes.
Thank you. Questions from the board?
I have a question. On the picture that you show here, the drainage that you have on the lower end here, how far away is it from the post?
Basically, well, it's the easement. My main purpose was to avoid placing the front yard on the easement. Right above the drainage, there is an easement line there. So, and then my fence goes. I didn't want to touch the easement, which basically belongs to the city. So let me see, let me think about maybe 4 feet or something like that.
Okay, let's consider it's 4 feet. That means there's an incline there, correct?
Yeah, it's like this. It's like a
Which
slope.
means from the lower end here to the post, about a foot difference? The incline?
I'm sorry, can you repeat the question again?
I'm sorry?
Can you repeat the actual question, like?
Yes. From the point where the drain is to the post that you have, this 4 feet distance, like you're saying, there is an incline, correct?
Yes, it
Okay.
goes all.
How high is the base of the post from this drain here? The difference, 1 foot, half a foot, 12, 18 inches, 2 feet?
Well, since it's not very far from the drainage, I think like maybe a foot or so, because
A foot or so, and 4
we
feet,
need to leave. We need to let the water go down.
Okay, and that's a foot, let's assume it's a foot, 12 inches. And you want a 6-foot fence, you already have a foot from here and 4 feet, that's 5. Which way you want to go on this?
But if
base.
you,
I'm going to interrupt both of you now. I would say this is, the questioning has to do with the actual evidence itself.
This
And
is a new evidence.
Right, but it has more to do with the actual evidence in support of the application, not whether or not the evidence is new and has yet to be considered. So those are, I would ask that you just limit your questions to, have we seen this before, have we not seen this before?
We haven't seen this before.
Okay, again, and so the only determination for this evening is there testimony that supports there's new evidence that you haven't seen? All we're looking to do tonight is,
I
she's
see,
asked
okay.
for a rehearing. I do apologize.
That's okay.
Can I ask a question?
Certainly.
Are these posts that you have made, are those 4 foot to represent 4 foot?
4 foot, yes, yes, it's by
Because-
the law.
I'm counting the bricks in here, and the bricks in here show that it's only about 3.5 feet.
Well, my constructing company said that they measured it will be, they didn't put the cups yet.
How, do you know how
Cups.
deep, do you know how thick the bricks are?
I didn't measure them by myself, but I ordered 4 feet with the cups. They didn't put the cups yet because we are waiting for your decision.
Would you say that the bricks are 3 inches each?
Well, I'm sorry, I'm not really proficient in the construction. I ordered them 4 feet, then that's what it's supposed to be.
Well, I'd like to help you, though. I pretty much know they're 3 inches, and there's, on one of them, there's 11 bricks, one there's 13 bricks, and one there's 12 bricks.
You
So
know,
did you want to speak?
the area is very uneven, and that's why I was thinking about just putting a retention wall, but I cannot do it because it's all like this goes. So I guess they just constructed to the best of the topography.
Okay, but this is being shown to us as what the height would be, if 4 feet is what,
Again, I'm
Again,
sorry
it's-
to
this
interrupt.
is
These,
new
these
or
are
not
more
new.
questions that would be pertinent to if you grant a rehearing and you're going to consider the evidence for the application.
So at this point, I suppose we can acknowledge that these photographs are of something new, right?
correct.
We all agree about that. The signatures are certainly new. This article from the newspaper was not produced before. Simply because there's new evidence, does that mean that we are bound to move forward with the rehearing?
And I will quote from the ordinance,
Thank you.
if the board finds that there is compelling testimony that there's new evidence to be presented, then the board is required to grant a rehearing based on a vote. So there does need to be a motion made, there does need to be a vote taken, but if there is enough testimony to compel that there is new evidence that has yet to be considered, then yes, the board is required to grant a rehearing.
Okay, so we've seen all of the new evidence. we'll go for a motion.
Move to grant a rehearing.
Is there a second? Motion fails. That's the end of that. I apologize. We did not get a second to the motion for the rehearing. You can consult with Heather about options, but unless we have consensus on the board, we cannot move forward.
Okay, so you don't consider this as an additional evidence, correct?
I did not understand. What? Could you please repeat?
So you do not consider all this as additional evidence?
As a board, we're going to turn to the attorney. Before I open my mouth.
I would advise the board, again, that the only question you are to answer tonight is if there has been testimony presented that there is new evidence that you have not considered regarding this application, not the merits of the application, not whether the criteria have been met. None of that is to be considered. The only thing to be considered is if there was new evidence that was testimony that there is new evidence that you have yet to see. So if you have not seen this evidence before, then you are bound to grant a rehearing.
Can I have a question?
Please.
Can I ask a question?
If it is with regard to if you have...
Why wasn't this evidence presented the last time?
Because I didn't have this fence last time.
But you had this
I have
evidence.
nothing
But you
there.
had this picture the last time.
This is not my fence. This is just a sample I wanted to order. I just wanted you to see how it may possibly look like, because I didn't have these columns yet at the last time.
I'm sorry, did I understand that you said you didn't have this post the last time?
No, I didn't have these columns there. I didn't even have time to give it to Heather because they were constructed last week. During the last meeting, I did not have the columns, and I made this picture for you to basically see what I am talking about.
So do we need to go for another motion?
I would advise that the
So
board
the
reconsider
chair asked
based on
if we can
the
have
additional questions
Yep.
asked and
Right.
the additional advice given. I would suggest that the
Yep,
board.
so we're open for another motion?
I will second the motion then.
Okay, there we go. So we have a second to the motion. And roll call.
Ms. Sanner?
Yes.
Mr. Eisner?
Yes,
Mr. Burris?
Yes.
Mr. Rabowski?
Yes. You have your rehearing.
Can we keep this picture, or you want to bring them next time? If you can bring them the next time, I will appreciate that. Thank you. Thank you.
Thank you. Okay. Next application. 16-15, variance to reduce the front yard setback, 1601 Gulf Beach Boulevard.
Give me 1 second, let me get through the first application here. We have quite a lot of stuff. Okay, this is basically a two-part variance to reduce a front yard setback to 17 feet and 20 feet to construct a replacement home. There was a home on this property previously. It was vandalized, broken into and then vandalized and burned to the ground. As a result, what was left of the home had to be under our under our building code, had to be removed. As a result, the applicant has been trying to redesign a new home, realizing that he has an existing pool and an existing garage on that property and an existing driveway on that property in a location that would make sense for him. He's got an encumbrance on that property because when this was actually platted, back in, I believe it was 25, me a second here. Anyway, back a long time ago, 1925, they actually platted in roundabouts that were planned for this particular roadway. That never materialized. This is a standard, regular residential roadway, very similar to every other residential roadway in the city, except that right-of-way is still reserved. That right-of-way is reserved in perpetuity until such time as somebody petitions the city to ask for it to be vacated. And basically what the city does in that process is vacate their rights to that right-of-way. So the applicant in this case had two options. One was to go through the vacation process or to come before this board and try to request the variance. The vacation process is a little bit more cumbersome than a variance, and ultimately the right-of-way that they're going to actually impinge upon, they're not actually going to be in the right-of-way, they're outside of that right-of-way. Really the issue is that right-of-way puts onto their property, and with the required setbacks, it's the setbacks that require that, or that cause the variance, the need for the variance. So really, a variance is an appropriate tool or mechanism in this case to ask for relief, just as if they chose to do a vacation, they could go through that process as well. I have spoken to the public service director who agrees that we are never going to need to use that right-of-way. So that being the case, the city would obviously accept a vacation. More than likely, the board would probably approve a vacation of this right-of-way. But in this particular time frame, the applicant would like to get started, being that we're getting close to the raining season. They would like to get their house rebuilt. They'd like to be able to enjoy that house. So as a result, they've decided to come through the variance process. It's a minimal variance. It's not going to change the character of the community. The setbacks that are being imposed on that property are setbacks in a zoning district that was adopted long after this was platted. This was platted in a time we didn't have land development codes. We didn't have setback requirements. So the original house wouldn't have met these criteria anyway. Even if he put it right back in the same footprint of what burned, wouldn't meet today's setbacks. It wasn't built that way in '77. As a result, staff is recommending approval. The applicant does have that encumbrance on the property here. It's something unique. It's not unique to only this lot in the subdivision. There are other lots that have this, but the other lots that have already been built upon, so they're already enjoying a reduced setback because they were built at other times of history when those setbacks were different or didn't exist at all. That being the case, staff has no concerns or comments as far as this being an issue for affecting property values. It's not going to be a nuisance to the neighborhood. And with that, staff is recommending approval. At this time, I can answer any questions that you're looking for, but they're asking for a minimal variance. They've actually, rather than coming back and just saying, well, I just want a blanket 17-foot variance, they're actually asking for two parts for the two corners of the house that they need to meet that. So they are making the accommodations that they need to be a minimum request.
Any questions of staff? No? Okay. Would the applicant like to make a presentation? Mr. Vanderpool?
Hello. Hi, my name is Charles Vanderpool. My wife and I own the property at 1601 Gulf Beach. As Heather mentioned, it was vandalized and burnt to the ground October 28th, I believe, just before Halloween. And so it's been about 5 months we've been trying to move this project forward. We've worked with a couple of designers and an architect to try to figure out how we could make a house fit that shape. And our solution was 2 step backs. Since I applied for this, I've actually had another proposal by a builder, designer, gentleman that uses even less of that space. And I brought copies of it. They're basically in the same place, but it's virtually half to only a third of what I'm asking in the first one because the shape of the house has changed. I've got some copies of this that I would like to present.
Procedure?
If we're amending the request, then generally, if you're amending your request, being that it's already been advertised and this
Right.
hearing's already going on, you would have to defer the application to, and basically look at this data would have to be looked at by the staff.
Are you married to the new plans? Or are you okay with the
Yes,
old
we are,
plans?
especially my wife, so she's couldn't be
The
here,
setbacks
but-
that you're now going to be asking for are less than the setbacks that are in this
Yes,
application.
Yes, considerably
Will they be
less.
The
de minimis?
board can recommend approval of these setbacks if the setbacks that you have are less than what you're requesting here when your actual application comes forward. That is not going to impact because you're actually reducing the request that you have. Obviously, we should have that information ahead of time of the meeting and be preparing an application according to what the request is. But there is the option for the board to approve the request that they have here, and if they're deviating from that request and they want a smaller setback, so it's going to be less of a reduction, then in that case, they're asking for a much more smaller thing, so we can address that at the time of permitting. However, generally, being that there's a new design here, you would defer this application, review that new information, and make your determination. I mean, obviously, staff's recommendation is probably not going to change. There's an encumbrance on this property. They have a physical limitation on the property. The fact that the applicant should be applauded for trying to reduce that even further than what they're asking for here, because a 20-foot variance, what's required is a 25-foot setback. Okay. So they're really working with us to try to do that. So I would defer to the attorney on whether or not we actually need to defer the application or if they can go forward with this, being that we're aware of the changes.
As far as the variances that are requested, if the new plans are asking for a smaller variance, there will be a smaller impact. I don't see that that's going to be a problem. If the board is okay, based on the presentation today, if the board feels that the application would be approved, then we would approve it as is. And then at the permitting process, with the plans changed, plans get revised all the time. If they're less and they don't exceed, I don't see that would be an
We
issue.
haven't gotten to that stage yet, just to the
Right,
cost of-
and in the event that you've got another designer or planner that comes in and you've got another set of plans, of course, you would, depending upon what the variances are, but the board can consider the application as is without the new plans, and then, during the permitting process, you would bring those up.
I have a scale drawing of the footprint, both the original, which was what I sent
What
in.
is the reduction from, what are we talking as far as the difference between?
Okay, where the variance one was requested, it was 17 feet instead of 25. The new one is 21 feet,
Excellent.
but it's to the left 5 or 10 feet. Maybe not that much. I'd have to measure it with I brought my ruler. I'd have to measure it, but I can tell you exactly how far it actually moves to the left.
And for the other variance, is it,
Yeah, the other variance is just to accommodate a porch, because I was able to get the house back. So that variance is only 23 feet.
okay.
Now,
So-
there's a right-hand post of the porch that, based on the scale drawings now, might impinge a foot. For the footer, we don't know yet.
The footer can impinge in that setback. It's basically when you're looking at the structural wall or what would be a structural wall, even if it's an open porch, whatever that line
Right.
is that comes down,
Right.
that's where we would draw that setback line. So the footer
Okay.
itself can actually protrude into that. We have yard encroachment requirements in our land development code that allow for some kind of flexibility. There's a percentage that you can actually go into that setback, so that will probably be fine.
Okay.
But you're still asking for a much smaller variance
Right, much smaller of the
than
same two
what we
variances.
have here. So I don't
Yes.
think that you're going to have a problem if you choose to recommend approval with this. It's just, it will be modified.
So do we have consensus on the board to move forward with this application?
Yes,
Yes.
Okay, go for a motion.
I move to approve it as is.
Oh, wait a minute, we're skipping a step. We're going to find out if there's anyone, are you finished with your presentation at this
I
time?
just wanted to present the drawings.
Please, let's have a look.
I didn't bring a huge amount of copies of the,
One is sufficient. I mean, we can pass it down. Why don't you pass it down to the board members so that they can look at it? It's more important they see it because I'm going to see it soon enough.
there's slightly revised, the description is typed on the second page.
Thank you.
And I have some of those. Actually, this one's, that's the old one. Okay, that's the new one. This one's actually, I think, better. Those are the two variances compared to the old one.
So do we have any questions from the board of the applicant?
Nope.
Okay. Members of the public opposing the application. This is your time to speak. Are there any members of the public opposed? Nope. Any members of the public in support of the application? Oh, would you like to speak?
Thank you.
Okay.
I don't think they count.
That's very kind, thank you.
You've got the vote of two folks in the peanut gallery.
Oh, they're better than peanuts, come on.
Would you like to make any closing statements, sir?
I can't really, I think I've presented everything I need to present to make my case.
Okay, then now we shall call for a motion.
I move to approve the applicant's.
Do we have a second?
I'll second that.
We have a second. Roll call.
Ms. Sanner?
Yes.
Mr. Eisner?
Yes.
Mr. Burris?
Yes.
Mr. Rabowski?
Yes.
Thank you very much.
And, sir, I like the new design better any which way.
Well, thank you, see, that,
Board members, can we just send one copy down to, actually down to Kim, so that she has one just for the record?
Yeah.
And then you can have the rest back. I only need one copy.
Yes, thank you. She doesn't need one.
We don't need more. We can return the other copies if you guys don't want them individually for your packets or anything. We only need one.
We'll just drive by and see it.
no, the goal was to actually try to fit that lot.
Chris,
Looks better.
Chris, can I ask Heather a question?
Please.
Heather, why doesn't the city just automatically go for the vacation of right-of-way on this?
There's a process and there's a cost associated with the vacation of property. We do have to notice, we do have a public hearing cost, and the city isn't required to vacate that. We can maintain it for perpetuity. It's not affecting anybody. But if a property owner, like in this case, wanted to have that vacated, we wouldn't certainly oppose it. It's something that we don't need that right-of-way, but we don't go out and actually give back right-of-way just because we don't need it. That would keep me really busy if we did that.
We've done that in the past. When I was on the BOC, we've done that. And what it does is put additional land and sometimes increased value back on the tax roll, so.
It does do
I'm just
that, but we don't,
curious.
as a general rule, that's not something that we go out and solicit to look to do.
I would think in a case like this where the gentleman is having issues, and it is because of the way the land was platted, that, concurrently with his appeal for variance, the city would go ahead and vacate that anyway.
In this case, if it was just this particular lot that was impacted, that might be appropriate, but you have multiple lots along that entire roadway that are impacted, and so you only have one property owner, so unless that property owner would want to petition for that vacation, the city wouldn't likely take on that additional necessary step, unless it was something that we felt like we needed to protect for some reason.
Right, okay. Thank you.
I did actually start that process and got letters of no objection from all the utilities to go forward, but this seemed to be a more expedient process to get the house built, so.
All right. Well, enjoy your new house.
Thank you.
Thank you, sir. All right. Next, we will hear from application 16-16. It's variance to reduce the rear yard setback at 1216 Windy Bay Shoal.
Okay, this is basically a request to reduce the rear setback to 12.5 feet to allow for construction of a glass sunroom. This is actually located in Tarpon Key, which is a fairly new subdivision, which this board is actually intimately familiar with, being that they asked for a sidewalk variance. So you guys have seen this actual plat before under a different project. That being the case, this is something specific to the lot. At this particular time, the applicant is seeking this additional glass room to allow for their enjoyment of their yard. They've provided some evidence about, bugs and noise and things. They are adjacent to an industrial area. Tarpon Key, when they subdivided it, was aware of the fact that that was an existing industrial area. That being the case, there is noise pollution that comes from those. There are dust and things that are kicked up from those industrial processes and those type of things. So the applicant has basically a unique situation here. There's not many places in Tarpon where you have industrial directly next to residential. This is kind of a unique situation in that case. However, there are other properties in this area that are residential. This is not the only residential subdivision in the area. There are other lots that are impacted. The conditions are not self-created. I mean, the applicant bought into the subdivision. The house was probably already built or was under contract to be built when they bought into that situation. So they knew about the industrial situation, but as far as actually knowing what kind of impacts they were actually going to have, that's something that you can't know until you move into a situation, how noisy that industrial property is going to be, how much negative impacts or pollution or dust or any of that type of things that you're going to have. It really depends. You really have to live there to have that understanding and appreciation, which the applicants clearly have attained now. That being the case, the applicants already have reasonable use of the property if you want to define the legal definition of reasonable use because they've got a house. However, there is a large perimeter fence around around the entire property. It's an 8-foot fence. It's the subdivision fence to separate the subdivision from the industrial and other properties that are along the Anclot Road. That being the case, you're not going to be able to see this glass room from the road. You're not going to be able to see this glass room from the internal subdivision because the applicant has a fence in their rear yard. So the only time that you're going to see this is if you are in the applicant's backyard, and I hope you're there by their request. That being the case, while staff can't support the application simply because it's not a minimal request in the fact it's not a physical hardship that's causing this request, it's really an environmental situation. It's a stretch for me to look at that and say, oh yeah, it's fine. However, there are extenuating circumstances. It's clearly not going to be visible from the street. It's clearly going to impact very few folks. And there's really not, from a planning perspective, real concern here. From a perspective of your land development code, it doesn't support this type of request, okay? It just does not. Those are regular lots. Tarpon Key was subdivided in the recent past. It doesn't have things like right-of-ways that don't belong where they are, that type of thing. It has regular shaped lots that meet the zoning criteria for that district. So this request exceeds my authority to recommend approval. So as such, I've recommended denial, but there is some extenuating factors here and limitations as a result of the other uses in the mix of the area. So with that, I can answer any questions that you might have.
Questions of staff? Anyone?
On the locator map, these lots here, are these commercial properties?
Hold on, let me get to that map.
Which
'cause
ones?
I would say no.
Right.
That's all part of the subdivision.
Yeah, that's all.
The lots are all subdivided out. There's two properties side by side that are actually developed. Then there's a whole list of ones that are just basically open. So like when you drive into the subdivision, it's hit or miss houses that have been built. They're working on some models and some different stuff that wasn't actually available when these guys got their home. They're doing some different things in the subdivision. There's actually a washout not very far down from them for concrete right now while they're doing the construction phase. Eventually, all this will be individual houses, but he's got a fence in his rear yard that goes the whole perimeter of the rear yard and connects to that perimeter back fence. So even with the neighbor, when they are developed, they're not going to be able to see unless they're elevated above. So if one of the models that they have in there do have 2 stories, happens to be built on that property, then they might be able to see from their second floor. But from the first floor, you're not going to see anything.
That's fine. Thank you.
You are very welcome. Any other questions that I can answer?
Anyone? Any issue with runoff, that sort of thing,
Any issue with runoff?
from the water, from the rain onto the
No,
structure?
no, there won't be any issue because they still have, gonna have 12 and a half feet to process any water that is gonna be on that property. So they're gonna still be in pretty good situation. Again, they're also a little bit higher up where they're located. They're not down on the water side, so they're a little bit higher up in the subdivision because of where they're located. So I don't think that they're gonna have any drainage concerns. And there is a drainage, area, like a swaling area right in the front of their property. So if there was water, it will run into that and go into the drainage retention area for the whole subdivision, because it's master drained.
All right. Anything else for staff? All right. Would the applicant like to make a presentation? All right. Come on.
Try.
Please state your name.
It's basically what she said. My name is Mike Barnes and my wife, Deanna. We bought the property. We bought it sight unseen. We came from Colorado, and we bought it off the internet. And we knew that there was a road there, and we asked the builder about the road, and he said, of course, oh, it's just a very lightly used road. It won't be an issue. Well, that was wrong. We can't even open the sliding glass door in the back of the house because from the hours of about 6 in the morning to about 6 at night, it's semi-trucks and garbage trucks, and it's industrial, and it's just, and it's so loud, and we were hoping if we could just get a little extra few feet to build the sunroom, it would help block at least from the main part of the house. The neighbor next door has a pool that goes all the way to the fence line, and the vibration from the trucks is so bad, it keeps cracking the pool, and they've had issues with that. That's how bad the traffic is behind the road. So basically, we're asking, maybe you could throw a little compassion our way and let us have a little extra feet on the back. We have an 8-foot fence. The builder, it was originally a 6-foot fence. The noise was so bad that they said they'd raise it 8 feet. So they took the whole fence down, they raised it to 8 feet, which helped a little. And it's certainly private back there. We probably have the worst lot in the whole subdivision. There's 62 houses there. We back up to Anclote Road, you know? So unfortunately, we paid for it and we're stuck with it. So.
Any questions of the applicant?
I have a question. On this new structure, how will the water come down off of the new building?
How the water come off?
Right. Do you have any gutter system?
It's going to have a pitched roof. The builder said it'd be a pitched roof. We contracted through Solara Industries, so it's like those prefab. They do the fab walls on site in the warehouse. They bring it out. It's a 4-foot slab. They put them up, and they'll have a pitched roof. So the water will just run off into our backyard. We have a perfectly rectangular lot, and there's no view whatsoever other than
A fence.
the industrial behind us. So we're not blocking anything. We're not a water view or nothing.
No, don't get me wrong, I have no issues with this. I'm just asking because the house next to you has a pool and a cage.
Oh, I understand.
And if there's, which there is down in Florida, heavy rain, and it comes down on this, will it be intruding on their property?
I can actually, that's actually a question for me.
It'd have to be a pretty
Okay, that's a question for you.
Essentially, what happens is the side setback, that's why we have side setbacks for that very eventuality. The side setback will allow for enough green space on the side and the rear to accommodate the additional stormwater that he'll have on the structure that would normally have fallen that would have fallen in that area. So there should be no impacts for runoff or that type of thing, especially because of the grading of this subdivision. In the area that they're at, it's the highest point of the property, really. When you go out there, you can clearly see that as you drive around, it slightly changes the grade, but it's a much gentler change in grade there than some of the other subdivisions we have, like up in Chesapeake and those other places where we've had variances where you guys have seen that drastic change in elevation. You don't have that drastic change here, so the water will probably slow down when it comes off the glass room and then be able to be percolated right into the soil.
Okay.
Any other questions? Okay. All right, thank you, sir. Any members of the public opposing the application? Any members of the public in support of the application? Okay.
Big group effort.
Staff closing statements?
I think I'm all set.
All done? Any closing statements? You all good? All right. So, consideration? Take, open for a
Motion?
motion.
Move to approve application number 16-16 for 1216 Windy Bay Shoal.
I second.
And a second. Roll call.
Ms. Sanner,
Yes?
Mr. Burris,
Yes.
Mr. Eisner,
Yes.
Mr. Rabowski.
Yes. Okay.
You have a sun deck, sunroom, something.
All right. Enjoy.
Enjoy it.
And do we have any staff comments?
We do have one particular staff comment. The staff comment that we have is related to our membership. We are now down another member. So Cindy, if you are interested in becoming a full-time regular member, please let me know or let Irene know, because we're going to try to do fill that position, not at the next board meeting, but the first real board meeting that they have, because the next one's a ceremonial meeting where they seat the mayor-elect and the commissioner-elect. So we're going to try to fill this position, provided we have somebody who's interested. So if you would like to be a regular member and move up from from an alternate position, we can request that. There's no guarantee that you'll get it, but we can
Right,
certainly
I
make that request. I don't know if folks have actually applied or not. No one's actually come to talk to me about this board since Mike came on board. I think you were the last one who called me about, seating on this board, what happens, that type of thing. So hopefully somebody from the Citizens Academy has applied, or there's somebody who is on the waiting list. So we'll try to do that, and hopefully at your next meeting, you will have a new member, if it's possible for us to have that happen. And that is all that I have for staff comments.
And minutes just whenever.
Minutes, you'll receive minutes as a result of our staffing situation. Kim's kind of been pulled away to do some other things that she probably shouldn't have to do, but she has graciously helped me to do that. Being that case, we'll have the minutes available as soon as we possibly can. We're a little bit behind with minutes, this board. I think we have one that is overdue, so we'll try to get that to you on the next meeting. It'll just depend on what availability I have for Kim to do that, because it does take some time to produce your minutes.
Okay. Staff, board comments? What do you got? Other? Then that's a wrap. We're adjourned.
Good job.
7:51.
7:51.
I apologize for being harsh.
No,
hey.
we have to understand.
You were harsh?
No, I was actually very delicate. I just